Today is a very, very beautiful day because, in my language, Dr. Daniel Ruhweza, they say that it's only when the dance has become so sweet that the young ones drum and the elders dance.
Okay.
So today, ladies and gentlemen, I am going to do the drumming. And not so many years ago, Dr. Daniel Ruhweza was doing the drumming because he taught me what I'm going to be asking him again. He taught me constitutional law from Makerere University. And when you people reached out and said, we need a consultant on constitutionalism in these contemporary times, there is no better person I would think about than Dr. Daniel Ruhweza. Now, I hold special relationship with Dr. Daniel. Number one is my former lecturer and a continuous lecturer because I keep learning from him.
I keep also learning from you as well.
Number two is a Rotarian, and we share the same Rotary Club. So we share a number of values.
Yes.
Number three is a man I have learned from to love God. So he's a man of many hearts, and I'm throwing out all these secrets for those who never knew, so now you know. So, ladies and gentlemen, my name is Tonekire Galandi. I am your host for Lego Tech Dialogues. It's a platform where we meet and find the bridge between the law and technology. We appreciate one fact that technology is affecting all areas. And as lawyers, we said we are not going to sit back. Let us move with the contemporary times. And therefore, this platform is a platform where we invite people with expertise in different areas of knowledge and bridge the same with the technology and how it's affecting us. So, Mr. Dr. Daniel Ruhweza, you are welcome.
Thank you. Thank you very much, Tony. It's such an honor to be here, by the way. You've been doing a lot of good work. I know we were supposed to have interacted much earlier, probably last year.
Teresa says God's timing is the best timing.
It's the best timing.
Maybe he reserved it for this day.
A time such as this one, you know, I like that.
Yeah.
That scripture in Esther chapter 3, I think. Never know it was a time such as this that you were made queen.
Exactly.
That we are friends. So I'm glad to be here, and congratulations.
Thank you.
You've been recognized in many spaces. I've been seeing some of the accolades that have been coming through, which means that you're speaking into a specific area which we actually do need. So well done.
Thank you. I keep saying I was taught by the best.
Amen.
And now people need to know when I say I was taught by the best, they need to know who I'm talking about. Ladies and gentlemen, without really wasting a lot of time, let me take the honor to introduce Dr. Daniel Ruhweza. Dr. Daniel Ruhweza holds a Bachelor of Laws from, I think, Makerere University. Makerere University. That one will rectify along the way. Makerere University. You know, Dr. Ruhweza is so democratic with his knowledge that he has rendered this knowledge to almost all these universities.
Thank you.
And therefore, everybody keeps fighting for him. The UCU people say that one is ours.
Yeah. It is true that I taught there. My very first teaching experience.
Yeah.
I started at UCU.
Yeah. Dr. Daniel Ruhweza holds a Master of Laws from the University of Kent.
Master of Laws from the University of Cambridge.
Oh, Cambridge, yeah.
Yes.
The University of Cambridge. And a PhD from the University of Kent.
Yes, University of Kent at Canterbury.
That's Canterbury.
True. Yes.
Huh? Now you really must appreciate me for bringing Dr. Ruhweza, because we are talking about a person who decided to study from where the origin of the law that came to the Commonwealth countries started from.
Yeah.
Doctor, you are really very, very welcome. We are really very, very excited to have you here today.
Glad to be here.
Thank you.
Looking forward to our conversation.
So, ladies and gentlemen, this conversation is going to be running for 1 hour. I also want to recognize the presence of Honorable Shaka Stephen Gashaija, MP in Tebe Municipality. Honorable Shaka Stephen is my partner here. If I don't recognize his presence, the man may decide to reduce the dividends.
Yes, and I think I know him as well.
And Mr. Odul Anthony, thank you for joining us, and so many of you. So, Doctor, today you came because people requested that you actually join us. So it's not just by coincidence that you are here. There has been a call and a request. I think in times like these ones, we need an expert on constitutional law from a practical perspective, a person who has lived it, to talk to us, the lawyers. We felt there is no better topic than looking at digital justice and constitutionalism. You are an expert on constitutionalism. You have written papers about constitutionalism. You have taught constitutionalism. So when we talk about digital justice, basically we are meaning the use of technology and electronic things like electronic case management system, virtual hearings, using technology ideally to deliver justice. Yeah, and when we talk about constitutionalism, we are looking at deriving power from the public in the constitutional law you taught me in layman's language. So when I look at what Doctor taught me not so many years ago, and what's happening today, is the reason why we came up with this topic. And we are confident that you are the best person to actually speak to us. So, Doctor, I think for purposes of this conversation, we are going to themate this conversation into 3 themes. One is access to justice. The other one is the right to a fair hearing. And then the questions will be as broad as possible for you to have a latitude to talk to us. And I will start with the digital justice bit of it. Not long ago, our courts have rolled out where we are saying virtual hearings, where we are saying that they have rolled out ikimis. Today now, lawyers like Namugera can, in the comfort of their seats, file without necessarily going to court. Today, they are able to receive judgments without, first of all, appearing in person. That is digital justice. But also, there has been a question that when you look at constitutionalism, from the constitutional point of view and equal justice, there has been a question of whether or not this digitalization of the justice system is not creating a digital divide. From where you see it from your expertise, what is your opinion on the balance between constitutionalism and digital justice? Thank you.
All right. Thank you very much, Tony. This is a good question and also a good space to be. I greet our listeners. Thank you for supporting these spaces, and thank you for having me here as well. Let me first start by talking about constitutionalism,
Yeah.
which has ended up being my pet subject.
Yeah, yeah.
When we talk about constitutionalism, I've often borrowed a definition which encompasses people's ways of life,
Yeah.
people's traditions, people's traditions, cultures,
Yeah.
their thought processes, their attitudes,
Yeah, yeah.
and their belief systems,
Yeah.
which all culminate into the fact that everyone who is in a position of authority, as well as those who are being governed, are subservient to a grand norm, a specific law, a mega law.
Yeah.
That there is a law that holds all of us accountable. And that has come out of our thought processes, our traditions, what we believe, our attitude towards certain things, all culminating to the fact that at the end of the day, we all need to answer to a law, the law that governs all of us. That is what we call the culture of constitutionalism. That you and I, even if we are not in positions of governance, or we may be, we think in a certain way. We have an attitude towards the way certain people are doing things. But we also have a duty on our own duty to ensure there is respect of the rule of law and so on and so forth. Good governance, etc. Now, when you talk about digital justice as part of the constitutionalism culture, it begets the question, where is digital justice embedded? And in my view, digital justice is embedded in the whole concept of access to justice. And when we say access to justice, we are really talking about the ability of all and sundry to receive a remedy or a protection from all forms of justice providers. Because oftentimes we talk about the courts and we think that access to justice is strictly about the courts. No. There are also other normative orders that provide justice. Traditional courts, traditional spaces, religious spaces, quasi-judicial spaces, among other things, all operating in the same time and space and all providing justice in one form or another. That is why, for example, when Thomas Coelho, having served his time, if God gives him life, a time is going to come when he will have served his, I think it's 50 years.
Mm-hmm.
He has to be placed somewhere. He'll probably want to go back to the home where he never had an opportunity to grow up as a child like anyone else. Now, that space is also waiting for him. The same as on when in the ICC,
Yeah.
that space is waiting for him to perform another form of justice, quote unquote, which is not captured in our normal courtroom spaces,
Yeah.
but a space that allows him to resettle in the very place. That is another form of justice. So that's what access to justice is. So that is where you now embed digital justice. And so I do agree with you. Look at the demographics of Uganda. We are probably 48 million.
Sure.
Maybe 45, 48. Those who can access electricity are probably a quarter of that population, if not less. Those who can access electricity are a bigger population compared to even those who can access the internet. Because for you to access the internet, you must access electricity.
Yeah, sure.
Okay, maybe you can access a battery or something, but also we now take it deeper. You must be able to have gadgets. Like now, for us to have these Twitter spaces, we must have a certain type of mobile phone.
Exactly.
Not every mobile phone, not every computer can help us access this kind of Twitter space or X space. And I have a clear example. Yesterday, I had an interview with a possible funding from abroad, and we were having Microsoft Teams. One of the computers in my department failed to work. I had to use a laptop. Okay, so now it means therefore that those who can access justice using digital spaces are a microcosm of those who can access electricity or internet, who are a microcosm of the whole population. Now, Uganda is known to be a low, least developed country.
Yeah.
We are still fighting to get into middle income, which means that the economy of the majority of Ugandans is not as big as we think. We are doing well, yes, by all measures, but we are still very far from where we are supposed to be. Okay? So now, the biggest population of people who need justice are poor. They are poor. That is why when we are talking about access to justice issues, it is normally widows, children, the juakalis, and so on. You and I, we can afford good lawyers.
Yeah.
Or at least, if I cannot afford you financially,
Yeah.
I can use my relational capital.
Social capital.
Social capital to ask you to represent me on a matter. You know? And that has been my story. Because I know someone who knows someone who can, you know.
Yeah.
Now, the majority of people don't have that access.
Yeah.
Later on, have access to digital instruments like we're talking about. Now, I am a big fan of ECMIS. I'm a big fan of all these innovations that have been made.
Yeah.
Please do not get me wrong. I'm just saying that we need to be honest and face the brutal facts.
Yeah.
And I think I heard this being said by one of the justices of the Court of Appeal in a workshop, saying how many people have this access.
Yeah.
All right. So whereas judges are able to do certain things, whereas you and I can file our cases on our laptops in the comfort of our bedrooms where there is internet, where there is electricity and security, the majority of people have not yet gotten there. As the Budonians say, who I call, who are our big brothers, we of Mwiri, Gachari Mabaga. Now, am I saying it's a hopeless situation? No.
Yeah.
It means only that we need to work harder to ensure that more people can access electricity, more people can access the internet, more people can actually access gadgets in order to do what we are doing in this kind of space. So that is where we are right now. And I believe it is a step in the right direction. I give all credit to now retired Honorable Dr. Justice Egonda Ntende, who is a Mwirian, by the way, for some of the things that he started. We are going in the right direction. I give credit to you and to Uganda Law Society for the advances made in digitalizing legal practice. But at the same time, we have to be honest. As you saw in the case of the appeal by Dr. Not appeal, the application for bail by Dr. Miriam Atembe, that at the time she entered court, the application had not yet been uploaded on the ECMIS system. Now, even if the application was ready and prepared, and then there was a power blackout, you would not hear it. Yes. So therefore, we need to continue pushing for digitalization, but at the same time, not forgetting that there are many other people who have not yet gotten there.
Wow.
Yes.
Wow.
I know it's a long story, but I wanted to set that stage.
I can tell you, first of all, I know that I'm affected like any other person who is your student, because you are very, very passionate about teaching to the core. Yeah. So you bring out something, key principles in this conversation, Doctor. One, access to justice. You clearly put up a very, very loud clerical call. Yes, we are somewhere, but can we be able to look at infrastructure issues so that everybody can access justice? So that takes us back to what you talked about, that we are able to benefit from the grand norm. Yeah? And it's basically from there that I actually want to ask the next question, that, Doctor, you talk of defining constitutionalism, that we should, all of us, irrespective of whether you are poor, whether you are rich, whether you are very educated, whether you are uneducated, oba osindika kigali, oba wasomera mwiri, oba kanambatiko.
That's
You know this
one,
mwiri.
kanambatiko. Yes, yes.
Yeah, so we should all be, derive justice from the grand norm. There must be that big law which we all subject ourselves to.
Yes.
If I can remember the constitutional law you taught me. And it's from there that I want to you, as one who has trained so many lawyers, in contemporary times of our nature, because we are in a younger democracy. We must accept that. And when I
say 60-something, not yet even 70 years old. Yeah.
The other day we were, I think this year, America was celebrating 250 years of democracy.
Yes.
Yeah. We have not even reached a quarter of their democracy. So and that brings me to the grand norm. What, in your opinion, how best should a lawyer in the contemporary times be able to support constitutionalism? It's quite a broad and tricky question, but I would want you to, from an academic point of view, from a parent point of view, from a citizen point of view, from an experience point of view, from a consultant point of view. I know for a fact that you have advised so many states and also written so many papers. When we talk about constitutionalism, in your opinion, how do you think the lawyer can help support the constitutionalism, the rule of law, so to say?
Very good question. First of all, as lawyers, we need to appreciate that if anyone is going to teach, educate, and push for the culture of constitutionalism, it's going to be us, the lawyers.
Exactly.
Anybody, because one of the core subjects we study is constitutional law.
Yeah.
And the reason we study it in our first year is because it is the foundation for everything else.
I hear you.
No law, even if it's in intellectual property, like my good friend Dr. Kakoza is passionate about, even if it's corporate governance, whatever it may be, no law can be grounded outside the Constitution. And respect for that law, the practice of that law, the amendment of that law, the strengthening of that law, all is grounded on the fact that we all appreciate that without the law, we cannot proceed. That is why in his book, A Man for All Seasons, I believe his name is Robert Frost, and I ask our listeners to correct me. When he writes this fictitious play, A Man for All Seasons, he talks about the character of Thomas More saying that I would rather remain in a forest of law than cut down all the trees. What was he trying to say? Do not, as a lawyer, seek convenience for your client, whoever that client may be, by subverting the law, hoping that having succeeded, you can chest pump and everything is okay. No. You must protect the law so hard to ensure that it protects both you and your adversary. Because should the forest be cut down, all of it in totality, we all suffer. So a paradigm shift must come for lawyers to begin to understand that, first of all, we are officers of court. That's why we are called to the bar. We are called to the role of advocates before who? Before the Chief Justice, as represented by the Chief Registrar. And so our primary duty should be to ensure that let law be done. There is a quotation, let justice be done though the skies may fall.
Wow.
Or, if you remember, the law would rather protect would rather set 99 prisoners or guilty people free than convict one innocent person. The idea is that if we uphold the sanctity of the law, we are all safe. If we use the law as a launch pad to attack the other and not ourselves, a time will come when the law will have no space to sit. It will be imbalanced. So you and I as lawyers and those listening to us primarily must see that an attack on, first of all, a lawyer is an attack on all of us. The way the Americans do it, you touch their citizens, they will come for you. Regardless of whether that citizen was contributing hugely to the economy of America or not. But as long as they are a citizen of America, they will come for you if you do anything to them. Same as Israel does it. So lawyers, first of all, therefore lawyers must protect the law. Whenever we see the law being either abused, mismanaged, badly amended, etc., we should stand up.
Wow.
Not because that's where our bread is buttered, although that is where our bread is buttered, but also because of the fundamental issues that come when there is no more protection from the law. Because when the protection of the law goes away, then you have no vaccines. You have no antibodies. Your body starts fighting itself. And that is the worst place any lawyer can be. So what then can the lawyers do? Stand and speak out. Speak out. You don't have to be nasty in speaking out. If you choose, write something. Blog about it. Appear in spaces. Teach. You know, when I go to the village after the Sunday service, my mother's village church, after the Sunday service, oftentimes I am invited to speak to Omuntu Wawansi.
Wow.
And tell them about the law, family law, what, land rights, blah, 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 etc. You know? Teach, because for 4 years you have studied over 50 laws. That's why it's a Bachelor of Laws.
Yeah.
Now, how can you keep all that content and keep quiet and not give back to the society that has told you? That's why I appreciate barefoot lawyers and yourselves for these simple, anecdotes that they share with the rest of the world regarding the law. So that's the first thing. 2, when my brother is in trouble, what will I do? That song, I'll stand up and what? Fight.
Yeah.
Even though I don't agree with you, Mr. Tony Chide, on something, When it comes to your right to practice law, express law, do whatever legal, I must support you. Because when I support you, I'm supporting myself.
Exactly.
You probably remember Philadelphia by our mutual author, John Grisham.
John Grisham, yes.
In the character, Tom Hanks was facing Denzel Washington on different sides.
Exactly.
But a time came when Tom Hanks went to Denzel Washington and said, I need a lawyer. And the way I have battled with you in court, you're a good lawyer.
Exactly.
You know, we must accept that there are lawyers who are good. They may not be in our law firms. They may be on opposite counsel, but let's accept. So when they are struggling, let's go and fight for them. Number 3, we must advocate for the amendment of bad laws or the repeal of bad laws. It is not personal. It is for the good of the nation. It is for the good of humanity. You see? You know, in his letter from a Birmingham jail, Dr. Martin Luther King Jr., and this is one of my favorite writings by Dr. Martin Luther King Jr., he said that challenging a bad law is a sign of the ultimate respect for law. You're challenging a bad law. It shows you that you have the ultimate respect for law.
Wow.
But some of us, you see a bad law, and we even forget what Pastor Numola challenged us in Nazi Germany. First they came for so and so, now you can see. First they came for politicians, we shut up. We did not speak.
We didn't.
Then they came for I don't know which other group, we kept quiet. Now they've come for lawyers, some of us are still quiet. Now they've started attacking mothers, arresting mothers and so on. We must speak out. You get it? When I saw, and with due respect, when I saw Dr. Miriam Matembe being carried into the courtroom, you see Dr. Matembe's son and I were in the same primary school. We're in the same class in P7. I was like, this is my mother. They are come. You know, it's now my mom. And I am still quiet. Okay, for me, I'm not quiet. I speak out, I'm telling you. So we must speak out. So lawyers, God has given you that opportunity. Okay, if you don't believe in God, the Constitution or your profession has given you a special call to do something, to say something, to advocate, to reach out, to speak. And it's not only to criticize, but even when something good has happened, like when she was granted bail, yes, speak out and say this is a good thing. Because some of us are too warped in negativity that even when there is a good thing that has happened, you don't even want to talk about it. She was granted bail. Appreciate the grant of bail, but keep the fight on. Finally, lawyers must, as you have done, because I follow you on social media, we must continuously keep abreast with the changes in the law, with what is going on in our nation. Whatever it is in the law that we can pick on. Now we have this monster called AI, artificial intelligence. You hear recordings. Now there is even an app that can make music. You just have to bring up the lyrics and the thing creates a song for you. You know? So a lot has changed. And we cannot be seen to be on the back pedal. If you hear of something good, let me know. As your brother in the legal profession. When you hear something good, that the training that is coming up and so on, let us work together. In so doing, we shall have equipped ourselves to protect the fundamental things: constitutionalism, the rule of law, and good governance. And please, I want to emphasize this to our listeners. There is, in some spaces, a misunderstanding that these things of good governance, constitutionalism, human rights, are activism things, and that is not the kind of practice I want to do. In 2007, I believe, we had the post-election violence in our sister nation, Kenya. The railway station, the railway line to Uganda was uprooted. Whether you supported the government, whether you did not support the government, whether you're in opposition, whether you did not know what was happening, whether you were nonchalant, whatever it was, all of us walked to work. Those who were mature enough at that time. We all walked to work regardless. So these issues must affect everything we do. You might be in a certain practice that never gets you to fight with the police for that season. Maybe you're safe at that point. But a time will come when you will need to have a functioning police, a functioning army, a functioning governance system. So regardless of whether you're doing, a certain branch of tax law, for us, just in the tax side, we have nothing to do.
For us, we are in Finitex.
We are in Finitex.
We are digital.
We are digital.
Mm-hmm.
My dear, when the electricity is switched off, or when, like you saw at the beginning of this year, when the internet was switched off, you could not file your bail application.
Exactly.
You could not do anything. Why? Because there was no longer access. So we must therefore, and I know I've spoken for a long time, we must therefore accept this responsibility.
Yeah.
It goes beyond our comfort, our pocket. It goes beyond our fine families who we want safe. What affects me affects everyone. And it's an African thing.
Yeah.
Ubuntu. I am because you are. Yes. Let me stop there.
Wow.
Yes.
Ladies and gentlemen, we are having Dr. Daniel Ruhweza, a Rotarian, a lecturer, and a Don of Law, Makerere University and other universities. He has published widely on constitutionalism. He has actually participated in public interest litigation petitions. Doctor is so passionate about human rights. And many of his students who have gone through his hands, including myself, can't help it to speak out. Because this is what he taught us. This is what we learned from you. And I think for me, without having the fear of diluting your conversation, I just want to amplify. My take homes for this conversation. Number one, as a lawyer, you took an oath. And you were called to the bar. So we have a duty.
Yes.
And in this oath, we swear to justice. So, Doctor, you remind us and say, wait a minute, you took an oath. You should have, if you thought you never wanted to be a lawyer, you could have probably gone and became a farmer. But as long as you're a lawyer, you have a duty.
Even farmers can't escape, Tony. Let me chip in there. Because Objective 29 of the National Objective and State Directive Principles of State Policy is very clear on duties and responsibilities of citizens.
Exactly.
Yes. One of those, interestingly, the one I like using is responsible parenthood. But among other things, seriously though, we have duties that are enshrined in the Constitution.
Yes.
To support the legal, to do many things in that Objective 2029. And amongst those things that we have to do is just upholding the laws of the Republic of Uganda. So even if you are not a lawyer, just the fact that you're a citizen, you have a responsibility. And there's even a whole chapter in our Constitution on citizenship, which even provides for more duties and responsibilities of the citizen. Not just to enjoy your right, but also a duty. A duty to do certain things. And Article 3, you are aware, talks about protecting the Constitution.
Yes.
Go ahead.
Doctor, when we were preparing this topic, my personal assistant, Theresa, sent it back and she had redrafted something. I said, okay. And in her redrafting, this is what she redrafted. She says, fear changes how people speak. And I think you have demystified that position. You make a clerical call, and for me, you quote a book which of a writer I love very much, that what touches a lawyer A should touch a lawyer B. We should all be concerned when the legal fraternity is attacked, when the lawyer is attacked, because that concerns all of us. Whether I am into digital practice, I don't need to sit back because this affects all of us. And I think for me, from the perspective, from the position of you as a lecturer, as a human rights activist, you also make another cross. People mistake that word activist, but we are all activists by nature because we are Africans. And you know, so I think
you could demystify that.
I want to just close this session by reading something which I felt so passionate about. Just give me a minute. We felt. I felt. I really felt good when I saw this. There is a quotation. I don't know if you read the judgment in the bail application for Miriam Matembe.
Yes, I did.
There is an excerpt which moved me. I felt moved. Yeah, I felt moved. I think I've seen some people tweet about it.
Was that about the
last lining? Yeah, the last lines on that ruling. They speak exactly to what you're talking about.
Where she says she's fortified in the decision.
Exactly. Permit me read that for you. Yeah. It says, I think this is her worship at Team Sheila Glorious. It says, I owe my allegiance to Uganda. I can only take a decision that I can live with a clear conscience. As a judicial officer with a Christian Catholic background, I am fortified in the decision I am about to deliver and pray that God shall be my judge. For me, I think when we read conversations like this, and then I listen to you as a constitutional lawyer and a don for constitutionalism, you were the right candidate to speak to us at times like these ones.
I mean, we've had a debate about that that quotation and the judgment. I thought it was quite an interesting way to put it, and a real sign of courage. Because in the times there is a lot of fear. There's a lot of fear of what could happen if I spoke out, what could happen if I made a ruling in one way or the other. But to see that, and I think the reason why her worship, Sheila team has been applauded is the fact that there has been a reluctance by judicial officers of late. When an application for bail is made, there's been a reluctance to grant bail. As you know that His Excellency the President has been quite passionate about not granting bail to people who have been suspected. But our constitution at the same time, which governs all and sundry, is very clear. When an application has been made for bail, judges and judicial officers remain human beings. You know, you should be able to see the state of a person who's been abducted for a long time, the age of the applicant, and the circumstances, even the kind of offense for which this person is being charged, to be able to make a decision in that regard. Yes, so it's a season to be courageous. I know it's not easy to be courageous. We are all operating in a process of fear. But I remember attending the Institute for National Transformation. And one of the lecturers in that institute said to us, do it afraid. Do it afraid. Speak afraid. You know, go to court afraid. You know, but do it afraid. Because you can't remove that fear from you.
It's normal.
Anything is possible. Something can happen to us. You could be picked up and so on and so forth. It's my hope and prayer that very soon this phase of doing things can be removed, and we can start following the law to the very core. It helps everyone if that happens.
Wow, wow, wow. Freedom of expression in digital spaces. You taught me Article 29 of the Constitution of the Republic of Uganda. And recently we had Andrew Karamaji versus Attorney General, where, you know, he contested the Computer Misuse Act. And court agreed with the applicant, the petitioner for this matter. Said clearly, the right to speak, the right to free speech, should be respected. There has also been arguments on how far can this right of speech be. In your conversation a few minutes ago, you create a balance. You ask us, let us speak out. Let us speak out. Let us freely speak out, no matter the circumstances. Even in fear, let us speak out. And the other key thing is, you may not necessarily have to be nasty. How do we create a balance? Because the Constitution gives me the right to speak out. So, from where you sit, from your experiences and so on, how do we balance?
You're right regarding Article 29, which Article 29 is really grounded in international law and treaties. International Covenant of Civil and Political Rights, the UN Charter, and others, that really recognize that we are born with certain rights as human beings. No wonder when a baby cries out as soon as he or she is born, we celebrate that these lungs can be used.
Yes.
When someone is living with difficulties of speech, it is a health concern. Right? We expect people to speak out. Now, because of that, the law has put in place, the Constitution has put in place the fact that there are certain rights which are non-derogable, and there are those which are derogable. Meaning that there may be some limitations to some of these freedoms. But the sanctions should not be criminal. The sanctions should not be criminal. Recently, my sister, Madame Anne Muheire, the deputy IGG, won a defamation suit against a blogger, I believe, who had said certain things about her. And she got justice. She was condemned in damages and so on and so forth. That, in my view, is the civil way to do it. Prove your case. Show that this person, beyond the expression of his freedom, went overboard and instead defamed me before the right-thinking members of public. All right? And that was what the law envisaged. Okay? Now, just because I have spoken out does not mean that I should be sanctioned with criminal charges and things like that. You're promoting this and the other. No. I think we should, whenever, and this is the thing about leadership, which is something I'm also very passionate about. Whenever there is an expression of a view, contest it with contrary views. Come up with a better view. It is unremembered that who says democracy is the contestation of ideas. I've even seen His Excellency the President, oftentimes, he will write to rebut a certain position. But arresting someone for what they've said, I think goes beyond it does go beyond the limit. In the United Kingdom, they have a space, Speaker's Square, it is called. You go with your wooden platform, stand in that Speaker's Square and say everything that is on your heart.
Wow.
They have provided a Speaker's Square. So if, Tony, you have a problem with me, go and cry your lungs out, say what you have to say, then go home.
You remind me of a popular quote by Isaac Kese Makade, where he says, as long as you decide to bring yourself out as a leader, then I will have my right to annoy, to abuse, because you are now a subject of public scrutiny.
That is true. You're subject of public scrutiny. I mean, you look at the cartoons that have been drawn about President Trump and other people. I believe that should be expected of us. If ever I was a leader of a certain magnitude, I would start seeing cartoons of myself, because I am now in the public eye. I should not be surprised that kind of, I mean, here I'm just, we work at Makerere University, and we have Dr. Spire. I don't know if you've invited him. He's always doing cartoons of leaders of Moasa, leaders of, So there are remedies, okay? And we should not criminalize speech. We should not criminalize speech. We should find civil ways of addressing issues. It's like if someone is preaching bad stuff, you preach the right stuff.
To
counter what that person is saying. But you see, the problem with criminalizing speech is that you even give what the person has said more leverage. You broadcast it even more. Instead of saying, no, I am going to write something that will counter what you're saying. And most democracies have had a rich culture of debate. You say this, I say this. You say the other, I say this. That's why I personally am not a fan of abusive interaction. All right, but that's a discussion for another day. I would rather you get me point by point. My problem is that sometimes we get into what we call ad hominem arguments. Where you say, but even you, Tony Kire, the other day I saw you doing X, Y, and Z. What gives you the right to speak? You have not dealt with the issue. You have instead diverted to the size of my nose, the size of my belly, the size of my shoe, the color of my eyes, instead of dealing with the content that I am talking about. So I would like to push that paradigm, that let's not, and for the forces that are out there, and I know sometimes our brethren in the prosecutorial office have a lot of difficulty dealing with some of these issues. There are questions about prosecutorial independence, prosecutorial discretion. But when such things come, they must have the backbone to say, no, this is a political debate. It's a political season. We should not criminalize everything that is political. We should not criminalize everything that is a freedom of expression issue. Debate it in the public square and let the people decide instead, So, yes, I don't know if I have answered your question, but I agree. Freedom of expression is a reality. It will not run away from us. It will never leave. I watch debates on the internet. debates on Christianity, debates on Islam, debates on rights, debates. There are so many, and you can actually pick some skilling there and be a great debater. Read widely so that you can make your points come out clearly. Oxford, Cambridge, and these places have a long culture of debate, where it is point by point and people are able to appreciate what someone else is saying, But once you bring in the law, once you bring in criminality, then you are nipping the debate in the bud.
Yeah.
Or once you use abusive speech like happened in Rwanda. Rwanda, some people are now being referred to as cockroaches and so on and so forth. You are dehumanizing the individual.
Yeah.
You should engage with them in a language that at the end of the day, you will win them over. Win me over with your words. In the Bible, Paul engaged in serious debates for 3 years.
Yeah.
Trying to convince people over. So in these digital spaces,
And
Paul was
the lawyer, by the way.
Hey, he was a Pharisee. Yes.
Yeah.
And yet he counted it as nothing. Okay. But therefore, on the digital platforms, which is the core of our conversation,
Yeah, sure, yes.
I often see people getting into abuse. They abuse people, they start calling them names, they start talking about their mothers and their fathers and so on, and leave the issue.
Yeah.
And yet, digital spaces are great spaces for you to disagree with me, for example.
Yeah.
There are judgments, for example, by the late Justice Mulenga in the sedition trial, sedition case of Onyango Bo, Andrew Mwenda, and the Attorney General, where he says that, even the sharing of bad information is protected, is protected. So, in the digital world, where information I know can easily go from China to India to America, all over the world in a matter of seconds, we must continuously engage in debate. That's why I like the issue, the guys in America called fact checkers.
Yeah.
During the presidential debates, they are fact checkers. You say something, someone is immediately typing to check whether what you're saying is true or false, and posts it there to challenge you. And I think that is how society develops. Lastly, all societies that have developed have think tanks. Think tanks. And Dr. James Magara has written a very good book after his doctoral thesis on think tanks.
Yeah.
China has over 300 something. I don't know if they're in the thousands. America in the thousands. There are even statistical data. How many think tanks do we have in Uganda? Which are spaces where we are just thinking, planning, thinking, bantering, debating, wondering, planning, just thinking spaces. Now, in a thinking space, everyone comes with their different view.
Exactly.
Yes. Now, I should be allowed to express my view. For example, if I say that elections can be done better, I should not be branded the what? Opposition and so on and so forth. No, I'm just saying there are mistakes that happened, okay, in the election. I should be in position to say that, and someone will counter and say, no mistake was done. Then I'll bring what I consider a mistake, you contest it, and we have a conversation about that for the better. That is why when you're talking about us being, when we did the amicus curiae application in 2016 as law dons, that was the idea led by Professor Oloka and Professor Chris Mbazira. The idea was to say, how can we contribute to a discussion of making better elections? So anyway, I'm just saying that on the digital space, let the conversation change. Let the way we debate change. Let's not get into ad hominem abusive. Let's avoid those ad hominem arguments. Let's avoid those abusive spaces. But let's deal with the content. With the content, it is again Martin Luther who said he has a dream that one day people black boys and black girls and black girls will be playing with black boys and black girls will be playing with white boys and white girls in the same space. That you will judge them by the content of their character, not the color of their skin.
Yeah.
So people may not like the fact that I'm light-skinned. Fine. It is a decision of nature, a decision of God. But listen to what I'm saying. If you don't agree with me, cite your sources of authority and say, I don't agree with Ruhweza on point X, Y, and Z. Ruhweza has miscited the Constitution, he's miscited the law, and therefore it's not something for us to follow. We'd rather follow this other one.
Yeah.
I think there will be developing our country.
Wow. Yes. Now, Doctor, I will not want to deny the listeners' opportunity. First, I'm going to pick just one or two questions that have been sent by our listeners, and thereafter, we'll open up a bit of space. So, the first question which has been sent is, the Attorney General directed a halt to prosecutions under the nullified provisions of the Computer Misuse Act, but the existing convictions remain undisturbed. Is this an adequate remedy? Does it leave a gap in constitutional justice? That's question number one, which has been sent in. Number two, what lessons should legislators draw from this judgment when drafting future cyber law or AI-related legislation to avoid a similar constitutional vulnerability?
Very good questions. Ideally, so one of the subjects I teach at Makerere University is comparative constitutional law, the master's course. Now, ideally, one of the concepts we talk about is you shall not convict someone for an offense that did not exist at the time that that person carried out that action.
Yeah.
All right? And I think it is grounded in proper law and legal positivism. And in my view, it makes a lot of sense.
Yeah.
Okay. It may be unfortunate that at that time a law has been quashed for being unconstitutional. Some convictions have indeed happened.
Yeah.
A good government, for example, has all powers to decide to make restitution for individuals that have suffered as a result of a bad law. Okay? But it may not be practical for there to be retrospective application of a law. Remember, it's the law of the government.
Yeah.
And I think the judges at the point they are asked legally, is this law as it is today constitutional? And they make that decision. I don't think they have the power to apply retroactively. That retroactivity can come with a lot of big challenges, in my view. And but I also know that there can be remedies. All right? For example, your conviction can be quashed.
Yeah.
The Innocence Project in the United States of America fights for the rights of persons on death row.
Yeah.
Many of them convicted using poor evidence, lack of science and forensics, biased juries, and so on and so forth. And some have suffered have been in jail 30 years, and so on and so forth. So what happens with that Innocence Project that I have seen in America is that when the conviction has finally been quashed, that person is paid in the hundreds and thousands and millions of dollars for the suffering they've incurred over the past years. And I think that is a good remedy going forward.
Wow.
Lessons for the draftsman.
Yeah.
In my, I'll call it short career
Long career.
short career of dealing with some of these matters and analyzing them. I have seen that it's important that every law we draft, if you are a draftsman, you must take it seriously. What do I mean? A law can affect generations.
Yeah.
Look at the decision in ex partemat of 1966.
Yes.
It has continued to create havoc and damage to Uganda since 1966.
Wow.
I think we're doing 40 some, or coming to 40 years.
Your lawyers here
Yes.
who have read the Ghost of Ex Partemat
Yes.
by Professor Loko Nyango.
Yes.
Yeah.
So it has affected us fundamentally. Just that one judgment.
Yeah.
If that judgment can affect us like that, how about a law? Now, for a law, let's look at the 1900 Buganda Agreement, which divided land, created the haves and have-nots, removed land from Bunyoro Kitara Kingdom, gave it to Buganda, allocated land to different people, and so on and so forth, created different types of land tenure systems. That one law or that agreement that had the force of law, see what damage it has caused.
To date. Yes.
To date.
Yeah.
We are still struggling with this thing that originated from Sahari Johnson and those who signed the Buganda Agreement. No wonder Daudi Chwa, when he was of age, when he read it, it is reported, he said, this is what I've received is Vyoya Byanswa. Meaning the wings of the termites that are erroneously called what? Ants. I've gotten nothing.
Yeah.
Because Article 6 alone changed the trajectory of leadership in Buganda Kingdom.
Yeah.
Insofar as you can only be recognized as the Kabaka with the permission of the governor. All right? So, history must teach the draftsman the damage that can be caused by a badly written law.
Yeah.
Which badly written law, by the way, does not only affect everyone else, but includes the draftsman as well.
Yeah.
Or the draftsman's children.
Yeah.
Because you may think I am safe, but a time will come when you've lost that position, or when you've retired, And so it is important, therefore, that the draftsman draws lessons from history, first of all. Two, the draftsman should also draw lessons from comparison.
Yeah.
How has Kenya done it? How did China do it? When you're passing NLO, when you're drafting NLO,
yeah,
there is a tendency for certain laws which are politically sensitive to be passed quickly.
Yeah.
Because there is a political end that wants to be achieved.
Yeah.
But it comes at a huge cost to many of us and to the generations that follow us. And personally, that is what often drives me. My sitting here is not for my own sake.
Yeah.
I'm sitting here because I don't want one day, if God gives me long life, to be seated somewhere and they ask me, what did you do when you saw certain things happen? What did you do? What did you say? How did you act? I want to be able to stand proud and say, at that time, when Chile invited me to his ex-space, I spoke.
Yeah.
When Edison Karuhanga invited me to his ex-space, I went and spoke.
Yeah.
When an opportunity came for me to do X, Y, and Z, I did it. Because we are going to be tested. We cannot run away from it. In fact, all of those who are listening to my voice, if you don't do anything, history is going to judge you. Wow. And you don't want to be on the wrong side of history. Your children are going to judge you. They'll say, but grandpa or father, why didn't you fight for us at the time? They will also ask the draftsman, what were you thinking when you drafted such a law? Are you saying your legal education did not expose you to X, Y, and Z to these hazards and realities and so on and so forth, you know. So it is important that the draftsman takes his or her job seriously.
Wow.
Let me give you a biblical analogy.
Yeah.
King Saul had been asked to exterminate a certain group of, I think they're Ammonites, or I forget, Amorites, I guess. And he did not. He saved some of the enemy.
Yeah.
And almost 4,000 years later, the enemy was now in a position
Of power.
To extinguish the Jews. You don't want that. So my duty as the person teaching, writing, advocating, negotiating, my duty as a person in the courtroom, my duty here to you to speak honestly, is to do as much as I can to avoid a situation where persons go away with bad advice, which they will implement to their detriment. The people who are in jail in Rwanda, for example, who participated in the genocide, because on YouTube you can watch their interviews. They will tell you, this is what we were told. We were told to pick machetes. We were told that these people who we are killing are not human. We are told this, and the other, and we implemented. So we must avoid the situation. We who are in leadership, we who have voices, we should speak in such a way that we build the nation instead of destroying the nation.
Wow.
That's why I'm so saddened by what is happening in South Africa. But because we are talking digital spaces today, I will not get there. But we all know what's happening in South Africa.
Wow. Ladies and gentlemen, we are having none other than Dr. Daniel Luhweza, a Rotarian, a Lodon, and most importantly, a person passionate about justice and constitutionalism. And for me, he strikes right on the nerve. And I will want to remember one of his lectures in Makerere University, talking about bad law and the draftsman. I remember in one of his lectures, he told us about a certain draftsman then, as he was Gracie Bingira, the deportation order. And these bad laws have gone on manifesting, and many times they come back to bite the draftsman at the time he least expects that bite. So I think the point is that, for the person who asked the question, is that what lessons that the draftsman learn is that the law is a double sword. You never know when it comes to bite you. Two, I think the other key take home is that we need to speak up. It is important. And I think for me, this call is a gospel to our senior lawyers we learn from. Because the young lawyers are yearning for guidance. But when things are happening and the senior lawyers are quiet because they are busy eating, they're in a comfort zone, I think we want to thank you for coming out and saying, look, the role of a lawyer is to speak to justice, is to see what is wrong and say, this is not right. And see what is right and support it. And say, we applaud here. You have just commented about cartoons. I can tell you, if there is one thing as a young man, I have always told people about President Yoweri Kaguta Museveni, is that I have grown up seeing all manner of cartoons of President Yoweri Kaguta Museveni. And I have not seen him at any one time saying, who is this one who has drawn me in this manner? I think for me, that's the spirit you speak to us, and I'm very, very happy for hosting you. Ladies and gentlemen, our time is very, very spent. I would want to ask my friend Teresa to check if there are any questions. I'm glad Isaac Semakade has joined us. That he will, I'll give him some few minutes to have a word or two. Ladies and gentlemen, it is 31 minutes past 8. And I would want to, can you make Isaac Semakade a speaker to say one or two words to us, and then we see how to wind this up. And if there are any questions, could you go ahead and, President Isaac Semakade, you're welcome on this show. In your absentia, Dr. Daniel Ruhweza applauded you for the digital transformation. So the speaker is yours. Please go ahead and take up.
Pleasant and encouraging to hear you and see you on the circuit, speaking circuit in during this last moment when many have chosen silence. I present the compliments of the Radical New Park Governing Council for that act of courage and patriotism, but also for the landmark conference you held on criminal justice, in which I was briefed that you presented a very transformative keynote on our current state of criminal justice. I would encourage you to bring it, ensure that it reaches the Bar Council. We have that challenge. And before and after I was elected president, I ensured, even at the risk of being eliminated, I ensured that I come to Makerere University and said that whereas if elected, I will use all my energy to create the widest rift between the bar and the bench, I will need to remove the rift that exists between the bar and academia. And immediately I got elected, I returned to re-emphasize that the days of divorcing academia from practice are over. The days of divorcing academia from judicial conversations, judicial recruitment are also over. We had an engagement with your colleagues, and we actually held a rule of law, our rule of law week in 2024 was organized in conjunction with Shuribek as a testimony of that new direction. During that particular week, we sort of locked horns, I guess, on some point. And so because I was really angry with your past liaison with the former DPP, who, in my view, had escaped scrutiny from the legal world. And to see you now provide scrutiny to the current DPP, for me it settled all this. In Uganda they say a banja ly'omwenge sasula mwenge. So that debt you have paid. I thought as a constitutional lockdown, you must never be seen in public to work for the DPP, unless the DPP was opening themselves up for criticism. Because the Ugandan DPP doesn't have the history or credibility to capture or co-opt those who are supposed to save the law. So it really gave me much pleasure personally to see that during our time in council, some of the people we've been able to criticize unapologetically, like you, take time to reflect and change course and demonstrate perpendicularity. So this is a testament not to weakness on your part but strength. I think it is Chinua Achebe who devotes so many books to criticizing his own kinsmen for being unchanging. If, being too stiff as a test of, manhood. Yet manhood can be demonstrated in many other ways other than sticking to old ideas arbitrarily. So I thank you for demonstrating progressive manhood. I think I could say that. That's the first thing I wanted to say. And I hope I can hear you receive the compliments, because I have a few other things to say.
Yep. Your compliments have been received, Bwana.
Why don't you let me? I yield for the time being.
Thank you, President Semakade. But that discussion we shall have at some other point, President Semakade. Yes, I would not want to divert from our.
Please do get us that paper so we can utilize it in our advocacy. The bar, it hasn't yet reached. So maybe that's something else to work on. When the blood and sweat is delivered, reduced into something important like that, it should formally be brought to those who can reduce it into practical imperatives. Breathe life, to help breathe life in our law and practice. You'll be surprised lawyers suffer also great lack of sensitization and awareness of these changes in the law that you've been talking about. So don't take it for granted that lawyers keep abreast with changes in the law. No, they don't. And we need to strengthen that bridge more intentionally. We submitted an MOU to the university, specifically the School of Law, but it's taking long, so maybe you can take the message to them. Maybe if the MOU framework was there, our rule of law department would also be a participant in all those activities and log these things. Anyway, the second thing I want to be able to do is to make a few corrections. For the record, you about 4 A Man of All Seasons was authored by Robert Bolt, not Robert Frost. Robert Frost is more reputable now because he recently, but he's a veteran journalist who helped bring credibility to Al Jazeera among the the journalists that left Western media and came to and made a home in Al Jazeera as a space for freedom of expression, which was being strangled by capital in the Western world. So that was Robert Frost, well known for his Red Sox I think the Red Sox guy or Green Sox guy. He had colorful socks. Everybody liked to watch him for that. But he probably also had the reputation of interviewing, was it Nixon? Apart from Bob Woodward, I think this was a Nixon interview that he has the famous interview with Nixon where Nixon says, rather matter of fact, that if a president did it, it's not lawful, it's not illegal. That was his understanding of immunity. And it's a conversation that literally ended Nixon's career. What after that, there was no recovery from me. So Robert Frost made his bonds from the Nixon interview. And then he became that kind of A-lister. People fear to take interviews with him because they would be career enders. So thanks for bringing both names alive. The second correction concerns Obo and Mwenda. The 2004 decision nullified false news, not sedition. The Mwenda decision, where Mwenda is alone, but the case was consolidated with East Africa Media Institute. That's a decision of 2010. It nullified sedition. It's a decision which has suffered decay and erasure from memory. It is far more important than even false news. Because false news was fasting. And it's first in time. But it was just one section. It's more important for the structured, analysis and rigor that put us on the map, as put our constitutional court, maybe it was Supreme Court, on the map. But the Mwenda decision of 2010 was far more important for Ugandans, and I'm a victim of its erasure from public memory, because sedition tends to be limited to insulting and annoying the president, or a person of the president, including some members of the president's family who wanted to claim access to coercive power of the state through sedition route. But actual sedition covers all branches of government, insulting and annoying parliament as an institution or its members or its leaders, and insulting and annoying the judiciary, including its leaders, and the contributing to hatred or contempt, the administration of justice. So all that is sedition, including, of course, insulting and annoying member of the district or local government. So that's how broad the sedition law was, and I'm just paraphrasing. So those are far more sections than one, than the one in Ubo. But like I said, it is a Constitutional Court decision. I think 15th or something, October 2010, and it has died from memory to the extent that a judge who
There's a Kenyan guy who provides them for me. Get them from Nairobi.
The Constitutional Court nullified 15 years
I
ago.
invest a lot in library.
Are you hearing me?
Yeah, we are hearing you.
Yeah, so that mistake that this done a lot. I hope as constitutional law scholar you help us bring back the supremacy of the Mwenda 2010 decision over the love after the romanticism we have about Obo and Mwenda eclipses Mwenda 2, which is far more significant in my view, because ordinary people are not so concerned about the news, they're concerned about the right to insult and annoy. And that brings me to the third and last, maybe the third and second last correction. Ad hominem, this is ad hominem, yes. I heard you speak to its discouragement and everything, but it's dangerous as a constitutional law scholar to say to speak like that without qualifying your remarks as being personal and possibly a form of moralism that comes from maybe your religious or socialization, so religious upbringing or socialization. Because as a pillar, as the vehicle or vessel of constitutionalism, you need to be very clear that ad hominem falls within protected speech. It's a form of opinion. It may rank lower in opinion. I think there's a prism of arguments where the great arguments you supervise PhDs and others. So there's that prism of arguments where ad hominem is at the base, and then you have your higher end, your more preferred forms of argument at the top. But it's no less a form of argument. It has a place in the prism of arguments. So a person can choose to make their arguments exclusively, extensively ad hominem. You may not like it, but it's an argument. And it must not be, it must not suffer the tyranny of elites who are likely, it's very dangerous when because no law scholar like you, if you don't make this qualification, then you take us back to sedition. Because those, unlike you, who have real power, will then say, no, even Professor Weza said you should not use abuse. What's the word that I use? You should give your criticism constructively, respectively.
Okay.
You see, once you take that route, then you open the door back to sedition and insert laws which, as you well know, have been outlawed across Africa through the device of the African Commission and African Commission Declaration, revised recently in 1929, which has been adopted in our case in Alternative Digital, 17th March this year. And the case, what's the case? For the African court case from Burkina Faso, it's a law recognized. So it's important as the beacon, as the filter of constitutionalism to sort of choose which persona you want to present in forums like this. You may want to keep some views to yourself privately and stick to the bare bones of constitutional law. Yeah. The last thing again is connected from there. Retroactivity and the question they asked, flowing from the decision of what are the proper consequences that flow from the decision in Alternative Digital and others versus the Attorney General. Petitions number 34, 37, and 42 of 2022. The Attorney General issued a guidance which most of you in the constitutional space did not take great effort to critique. The bar produced a critique of that opinion, specifically on the issue of retroactivity. I don't know if there's a contestation in the academic space, but if there is, then we need to have a full debate on it, a very serious one. What does Article 2 of our Constitution mean when the court declares an act, think, conduct void? When do the consequences of nullity flow? Is it post the judgment? Is it after the judgment, or it is void ab initio? does the court need to go further and explain which vote, the date, this confusion and chaos should be removed from our constitutional law. In other constitutions, like you have in South Africa, where courts were given, they debated this extensively and they gave their constitutional court a power to suspend a declaration of nullity, to allocate a different date for nullity, to allocate consequences. In our particular case, that kind of knowledge was available and it was rejected. Our constitutional courts, our governments have no wiggle room. Once a matter has been declared void, it is void from the beginning. It has the definition of void as the House of Lords had set it in the 1963 case of McFoy, Benjamin Leonard McFoy versus United Africa Company. The words of Lord Denning: if an act is void, it is bad and incurably bad in law. You do not need a court of law to set it aside for you, although it is desirable to get the declaration. But it was always bad from the beginning. And you will be relieved from any consequence that had occurred to you before the declaration. You cannot put something or nothing and expect it to stand. So, arising from the alternative digital decision nullifying the Computer Misuse Amendment Act of 2022, as well as the section now called, I think, 128 of the PCA. 128, yeah. Of the criminal libel provision. The consequences are as before. Every person that has suffered before the judgment has remedy. They have remedy under Article 23 Sabbatical 7. It's very clear. 23 Sabbatical 7. If you suffered a detention, a restriction, and the government had no power. So Article 20, actually 23, Sabbatical 7. No. Yeah, I heard you talk about 28, but 20 Sabbatical 7 is probably much. It needs your support. A person unlawfully arrested, restricted, or detained by any other person or authority shall be entitled to compensation from that person or authority, whether it is the state or an agency of the state or other person or authority. So if the state gave itself a power to arrest you, to restrict you, to detain you, convict you, and it is affirmed later that the state never had that power to begin with, you have a remedy in Article 23, Sabbatical 7. Our Constitution talks about restorative justice and historical injustices being redressed without these technicalities. This matter is very important. So I would persuade you to change the opinion that retroactivity is a decision of court. At least in constitutional law, no. That power was removed from them. Don't give it back to them through these arguments of and what the state can afford that I've been hearing you say. No. I think then I will go to finish the corrections. I would like to go to just 2 points. The first one concerns, again, I go back to the favorite subjects between you and me, the office of the DPP. I would like to suggest it to you in keeping with your call for think tanking that we now have 20 licensed law schools. Each of them is required to have a specific a very statutorily defined cadre of lecturers. Last time I consulted one of your colleagues, he told me that you actually have an association of law lecturers, but it's loose. We need you to build solidarity at that level and assign yourself some form of watchdogging in defense of the public. I think you have that right and a duty within your university status to teach, research, and participate in the community. Now, the community needs you to help us solve the problem which has run out of hand, called political persecution. The DPP escapes scrutiny from every available center of redress for many reasons, because they have endorsed the withdrawal, the loss of liberty. So people then fight to retain liberty. And once the cost of retaining liberty is too prohibitive, that coming back to correct error has always been our problem. Clients, would it even dare, would it even afford? So it seems that the only people that have the I can call it I don't want to call it luxury, but the privilege of being unaffected in the theater of contestation for liberty are the law lecturers. You have the capacity to look at the data, the depth of the DPP's carnage on the people's rights, and locate patterns and report about them, from an evidence-based perspective, and submit reports, if not within the local division, but beyond borders. Engage the African Court, African Commission, African African Charter rapporteurs, UN procedures, East African Court of Justice, to bring these special cases that arise from the patterns. Let us use the example of the Computer Misuse Act. I got overwhelmed as a private practitioner. I got overwhelmed as a practitioner who was tracking this carnage on young people. But the charges are out there. And if a university like yours, was able to gather them and analyze them, I think you could bring some discipline to that office. And that's just one family of charges. So I think my call is that don't preach to us about forming think tanks. Show us what a think tank of constitutional scholars can do for us in our lifetime, especially for your students who are now born as digital natives. And that space is very dangerous for them. And the danger is the DPP. I hope I've made the point clearly. So that's something you need to... I think the last part concerns our governance as the radical neighbor, and I I hear you speak and speak and speak, and you never seem to be clear on what the moment of the radical new bar means for freedom of Ugandans and for better conditions of practice for lawyers. I don't know whether you think we are an unwelcome aberration or we represent the wisdom of the majority of lawyers who understood that decorum had exhausted all arguments it could make, and table banging is the collective policy of the bar. I want you to be very clear on where you fall on that question. Do you consider us a nuisance or a useful and necessary presence as the bar makes its 70th decade? Thank you very much.
Thank you very, very much, President Isaac Semakade. I believe you know that the benefits of being the president, my friend, Dr. Daniel Luweza, the president of the bar, has had this 20 plus minutes. Ladies and gentlemen, I would want to give Dr. Daniel a few minutes to wind this up. We are overtaken by time and events. Please, Doctor, in a few words, would want you to patch this up.
All right, thank you.
But also, as you patch this up, I'll give you our last, our punching, our closing punch, which you should also put in your last few minutes. Our biggest listeners are not people in our age bracket, but they are the young men you have just rolled out in practice. Many of them look at you as the person they want to be or become better of you. So as you wind this up, your last question from Legal Tech Dialogues, what is your advice to that young lawyer who has just left law school and would want to become better than Dr. Daniel Luweza? What should he do? Thank you. So that is from me. Then you can respond to the president in a few minutes, and then we close this up. Thank you.
All right. Thank you very much. The president has said quite a number of things. I don't think we have enough time for me to get into that conversation.
Definitely,
honestly.
no. Yeah.
I've taken note. The conversation can continue between him and I. And I think the most important thing really is that this is the kind of dialogue that I would have wanted to encourage everyone who is listening to us to have, a discussion on ad hominem. His views are clear on that. I've expressed, my views on that area and so on and so forth. Requesting for a copy of the letter, of my speech on criminal justice and so on and so forth, which I can provide. No, let the conversation really continue, because I would not want to engage in that one at this point in time.
Of course. I'm glad that you have opened the conversation, and I'm sure the president will be able to reach out, and then you have this conversation expanded.
Can continue having the conversation in that regard. My advice to the young people who are listening in to me is, first of all, to acknowledge and appreciate them for allowing a new method of engagement. There used to be a time when we used to have Vimeza, Bimeza in I think somewhere in Luzira, along Port Bell area. Port Bell Road. There used to be a Chimeza there. I forget the restaurant, It was a food restaurant. I forget its name at that time.
There was also one in Charlie, as you go to Charlie Wajala. The place actually later became Agenda. You used to call it Agenda kwa Agenda. So it has still retained his name kwa Agenda. Yes.
Yeah, those bimeza used to be there, but I think at some point they had been removed and either outlawed or something like that. But I'm glad that we get an opportunity in these digital spaces to have that conversation. So I congratulate them for embracing. In any case, they are the villagers of these spaces.
Exactly.
You know, we are always learning a lot. I've been blessed to have some children, and they're always teaching me many things.
Yeah.
I have written a book. The book is We Don't Teach That at the University. And I believe that book answers the questions that you have asked. The last question you've asked me about having grit, maximizing the use of our networks, learning beyond our comfort zone, engaging in mentorship spaces, among other things that I have. Your network is your net worth, and so on and so forth. Spreading the catchment of the capitals where you want to invest. We've just been talking about John Grisham's books in your office. So in there I talk about intellectual capital, social capital, physical capital, spiritual capital, among others. All those capitals have a place, and all this is captured in that book that I write. We don't teach that at the university, Confessions of the University Don. I will not delve into detail because clearly your time is spent. But yes, I think I am one of the most easily reachable individuals where we can have further conversations. But I clearly know that law, as it was taught to us in those days, is no longer the kind of law as practiced today. I would encourage them to cut their niche. I like what, for example, Council Kayongo is doing. He has gone into fintech and so on. You are into the legal tech spaces. Professor Chris Mbazira has gone into public interest law, the clinic, and the new style of teaching, adopting more and more the Socratic method over others. And there's been spaces. The senior lawyers, of course, some have been very actively involved in mentoring and accepting the new normal. And then maybe two other statements is that the only constant thing we have in this world is change. So let's expect a lot more change that happens. We might have thought that legal tech and fintech and so on are the new normals, but they may not necessarily be that at the end of this year. Because even in the book I talk about the world is VUCA. It's volatile, it's uncertain, it's complex, it is ambitious. Volatility, uncertainty, complexity, and ambiguity. All those are operating in the same time and space, and we are always trying to continuously adopt. So let's be agile in that space. Today, I may speak as I do right now. Tomorrow, certain concepts may change. Yes, but let the conversation begin. Continue. I have said my bit. President Simakade has also said his bit. The debates can continue from this space onwards. Allow me to stop here.
Thank you very much, Dr. Daniel Olweza, for joining us today. Ladies and gentlemen, our topic today was digital justice, constitutionalism in the contemporary era. And we can't go beyond this. The take-homes are simple. Number one, preserve the law, even if it means for the sky to come down. Number two, speak out. because you have a duty to do so and hold what is right and applaud it, and what is wrong, speak about it. And ladies and gentlemen, honestly, without diluting the very rich cocktail of Dr. Daniel Ruhweza, let me wish all of you a good night. And may the good Lord bless you. Thank you.